drug policy is a very difficult and challenging area. It's intensely interesting, but it's very difficult because clearly drugs is something that excites people's emotions and quite understandably, it therefore often produces strong emotional, public responses in both directions, and there's a lot of polarised views around it. So actually trying to develop a vaguely rational set of policy recommendations within that environment is not at all easy.
The Act itself is an Act which is very, very heavily focused on supply control, and what that's tended to mean in practice is that insufficient attention is paid to the other aspects of drug policy, in particular questions of treatment, education and limiting problems associated with drugs.
What we have done is work very closely with the relevant government agencies, which is Justice and Health and Police and Customs, to identify the issues. We've consulted much more widely with interested stakeholders, including the Expert Advisory Committee on Drugs and the Drug Foundation and Shaw at Massey University and a wide variety of others, really to ensure that we're identifying the right sort of options. There is a very large pool of people who are actually prosecuted and convicted for both drug supply, very small scale sale and possession and use, whose offending is actually driven not by profit, not by the desire to prey on others, but simply because they are part of the drug-using world, who very often all have addictions or at least are in need of treatment or intervention, and the distinction between low-level social supply and personal possession is often a pretty artificial one. By and large, we still see the criminal law for that group as the first and very often the only response. We end up putting people in prison for relatively short periods. They often end up getting access to drugs in prison. There is nothing we do to deal with their dependency. They come out and the cycle starts all over again. When people are caught with small quantities of drugs that we believe are for their own use or maybe for very small scale supply to others, in the first instance we destroy the drugs, we remove them from them obviously because they're unlawful, and we give them a caution so that we warn them that they shouldn't do that again in future. And then if they accumulate 2 or 3 cautions, at that point we start using the criminal law. A second variant of that obviously is as part of or instead of a caution, we actually after the second or third time that they've been detected siphon them into a treatment or education program so that we give them access to relatively limited intervention, which may actually curb future drug use. Another option is simply to use what a number of overseas jurisdictions use, which are infringement fines, so that people who are detected with small amounts of drugs get a notice equivalent to a speeding fine. They have to pay the amount of money, but we don't have all the costs and indeed the negative consequences of criminal court prosecution and conviction.
Diverting resources away from prosecuting people who possess and use drugs and transferring that resource to detecting and prosecuting those large-scale commercial suppliers will do a lot more to minimise drug-related harm than prosecuting low-level offenders. Looking at treatment needs of that group is going to be a more effective bang for your buck, if you like.
Of course, if a controlled drug like cannabis is going to be used for medicinal purposes, there is an ability to apply for approval for it to be used as such under the Medicines Act, and even as an unapproved medicine it can be actually supplied by individual doctors under some circumstances. It hasn't been used like that in New Zealand. It has in a number of other jurisdictions, such as cannabis, where a particular form of cannabis preparation is actually supplied by the government. We actually think that because there is quite a lot of evidence that cannabis actually is effective in some circumstances as a medicine, particularly for pain relief, that it ought to be seriously considered. However, it is also obviously important to ensure that if we went down that route, the form in which it's supplied and the way in which it's supplied is appropriately controlled. I think at the moment the way we approach drugs generally is a rather peculiar all or nothing approach. That is, in relation to a whole bunch of things that are covered by the Misuse of Drugs Act and largely covered by the conventions, we prohibit altogether. But until we get to the point of prohibition, we largely have no controls at all, unless they're things that are classified as medicines, in which case we have some controls in the Medicines Act. And that really means that we have the rather peculiar situation where a whole bunch of substances can come on the market. They can be happily supplied and sold and commercialised and marketed in a fairly unrestricted way to the public until we get round to saying this might be unsafe or dangerous and we need to prohibit it altogether.
Coming back to the regulatory regime we've proposed for new psychoactive substances, I think, as you say, the key driver is to say we don't want the kind of commercialisation that's grown up around alcohol to grow up around new recreational substances. On the other hand, you may get a better control through regulating them than allowing a black market to grow. And that's kind of part of our thinking in terms of this new regulatory regime. I think a theme that has come through both in the consultation on our alcohol report and on the consultation we've done for the purposes of the Misuse of Drugs Act report is that there are gaps, and significant gaps, in treatment services, and they do need to be addressed. And that would be services whether you access them through the court system, the court orders for additional treatment, or whether they're simply people who are wanting treatment for addiction problems. What we have suggested tentatively in the report is that some kind of blueprint needs to be done for what's required over the next 5 years, and we've tentatively suggested the Mental Health Commission might be an appropriate agency to do that report. But I think it's important to say that this is an area which has been neglected. The existing Act was based on a report done by Blake Palmer in the 1970s, and even then they were talking about the need for treatment services to support whatever drug law you have in place, and the fact that there weren't adequate treatment facilities. Now, on the next review of the Act, more than 30 years later, I think the same theme is coming through, that treatment has really been the poor cousin of supply control, and we need to do something to get a better balance between the various limbs of drug policy. And what that does mean is that we need to look and invest more resources in ensuring that there are adequate treatment facilities.
We are going to be producing an issues paper in mid-February. We are inviting submissions on that paper by April. We will then be considering carefully all the feedback we get with a view to producing a final report for government around about the middle of the year or shortly after that. Now, we'll be listening very carefully to what everyone has to say to us. In addition to written submissions, we're very keen to meet with people. We'll be having a range of meetings around the country with interested groups, people who work in the area, people who have strong views on these areas. So anyone who actually wants not only to produce written submissions but to talk to us about it, we would welcome them getting in touch with us, and we can arrange to meet with them or talk to them in some other way.